Hello dear students, welcome back. Today we are going to continue with our civics chapter 3, the judiciary system. In the previous video we have seen what is judiciary. We have come across the Supreme Court, the subordinate court and the High Court, and we have seen that what were the qualifications that a person need to become the judge of a Supreme Court, the appointment method, appointment of ad hoc judges, tenure, term of office, okay, all these things. So today we are going to continue with the jurisdiction and the powers of the Supreme Court. Okay, now first let us understand the term jurisdiction. The jurisdiction is the power that a court of law exercises to carry out judgments and enforce the laws. That is, we know that in the court what happens, the procedure like hearing the case, then finally giving a decision by the judge related to that after many hearings. Okay, so that is what exactly you call enforcing of the law or implementing the law is what you call it as a jurisdiction. And the Supreme Court is the protector and the final interpreter of the Constitution. It has both original, so this jurisdiction is actually divided into many classifications. Okay, so we'll be coming to see that the original jurisdiction, advisory jurisdiction, and appellate jurisdiction. Okay, so let us go into detail one by one. What do you mean by an original jurisdiction? Okay, so original jurisdiction means the power to handle those cases which cannot be moved in any other court other than the Supreme Court in the first instance. Okay, so you have to learn this definition by heart as it is, because you cannot make any variations in this. Okay, and it's very simply and clearly explained to you. So original jurisdiction means that power to handle the cases which cannot be moved or forwarded to any other court. Okay, if other than the Supreme Court. So only you have the right to forward the case in the Supreme Court, but not to the High Court or in the subordinate court in its first instance. Means what? In its first case, first trial. Okay, so for example, if I make it more clear to you, suppose a case between the center and the state, it is there. Okay, suppose related two states are having a case, and the states are having the case related to the water facility. For example, few years back we had a same issue with the water supply from one state to another between Kerala and Tamil Nadu. Okay, so these two, so Kerala says that Kerala needs water and Tamil Nadu says that we are not ready to give the water, or vice versa. So in this case what happens is that then the case is filed in the first instance. Okay, now this case is filed in the first instance, then it cannot be moved to any other courts except to the Supreme Court. Okay, so it cannot be moved or forwarded to the Kerala High Court or no, neither forwarded to the Tamil Nadu High Court. So it can, if it can be forwarded, then it can be forwarded only to the Supreme Court. Now these original jurisdiction includes the center state or state dispute. So I gave you just an example of a state dispute. So same thing can happen with the center and the state. Okay, from the central government and the state government. Okay, so it can also happen between the state versus state or center versus state, like that also. So this is what you can see, that between the government of India. Now what do you mean when we talk about the disputes between the center or the state or state versus state? It is that between the government of India and one or more states. Suppose two or more states stand together and they will be filing a case against the central government related to any matter. Okay, maybe insufficient fund for any particular purpose, or maybe for any other charges that are imposed by the central government and they are not agreeing with that, they file a case against the central government. Okay, so this can happen. Then between government of India and any state or states on one side and one or more states on the other side. It can be like one side, there can be Uttar Pradesh, and on the other side there can be Uttarakhand, Jharkhand, Bihar. Okay, in that way also the cases can be filed. Okay, Then second, but there are certain exceptions. Second is that the protection of fundamental rights. So the basic, we know that the basic motive of the law and the jurisdiction is to protect the fundamental rights of an individual or of an organization or of a group or of a state itself. Okay, so the original jurisdiction, the fundamental rights of an individual, if it is violated, then such individual can directly approach to the Supreme Court. Now, the original jurisdiction, how it acts here, it extends to the cases of the violation of the fundamental rights of the individuals, and the court can issue several writs for enforcement of these rights. Okay, so we will discuss later about the writs. So writs means the return laws. Okay, that is what you call it as a writs of the enforcement of these rights. Any individual can approach, in that case any individual can approach the Supreme Court in case of violation of a fundamental right. Okay, now third is transfer of cases from one lower court to another lower court. Now how does this works? One lower court to another lower court. Okay, for example, under 19 article 139 A, it is inserted by the 44th amendment in 1978 that the Supreme Court may transfer to itself cases from one or more high courts. Okay, that means if these involve questions of law or cases of great importance, okay, that means the Supreme Court may transfer to itself cases from one or more high court. Now there might be certain, very seriously discussed matters. In that case, the Supreme Court and the cases are filed in 2 different or 3 different high courts of the different states. Then the Supreme Court can ask to transfer those cases to the Supreme Court. Okay, so that is transfer of cases from one lower court or another lower court. Now here lower court refers to any of the high courts. Okay, from there to, or even the subordinate courts, from there to the Supreme Court. Okay, and if this thing is done only in certain severe cases of great importance. The next is interpretation of the Constitution. Now what do you mean by interpretation? Interpretation, the word means that to go deeper into, to analyze and to find out. Okay, so interpretation of the Constitution is cases related to interpretation of the Constitution are exclusively handled by the Supreme Court. Now what type of cases again here? All the cases where interpretation of the Constitution, interpretation means much more detailed explanation and clarification is required related to the matters, amendments, rules, policies, articles of the Constitution, then it can be directly filed to the Supreme Court. The Supreme Court has the power of the exclusive jurisdiction in regard to questions to the constitutional validity of the central laws. Okay, so that is what you mean by the interpretation of the Constitution. So these are the things that you have to keep in mind. Now let us see what are the exceptional cases. I told you that there are certain exceptional cases in the original jurisdiction. Number 1 is that a dispute arising out of a tragedy, agreement, etc., which is in operation. Now suppose a case is already undergoing and its work and hearing, everything is undergoing. So in that case, there will be clash. Dispute means what? Fight, argument, disagreement of the opinion. So their dispute arising out of the tragedy. Now this dispute has arisen out of some tragedies that has happened and agreement, etc., which is in operation. In that case, the Supreme Court has been given exclusive original jurisdiction in any dispute, means it has the right to interfere. Then second is that in certain other matters such as interstate water disputes. So I gave an example already. Okay, interstate water disputes matters referred to the Finance Commission. In that case also the Supreme Court have an exception. Okay, then adjustment of certain expenses and pensions between the union and the states. So these are the 3 exceptional categories where this original jurisdiction shall not be extended to or shall not be taken into practice. Okay, So this is what is we learn about the original jurisdiction. So you have to learn the definition. It is means the power to hear and determine a dispute in the first instance of the court. Okay. Then next we will be coming to what do you mean by this appellate jurisdiction. Okay. Now from these terms only you connect and learn. Original means what? The pure one, the basic one, the very first one. Okay, in that say. So first instance, you can connect like that. Now appellate jurisdiction is a term derived from the word appeal. Appeal means what? To give a request. Okay. So appellate jurisdiction is means where you will be giving a request or you are appealing for the further hearing or for the further jurisdiction, right? So let us learn the definition. What do you mean by appellate jurisdiction? Means the power to handle the cases on appeal against the judgment delivered by any court in the country. Okay. Now we know that we have many subordinate courts. We have panchayats. We have above that we have the civil courts. Okay. We have criminal courts. Okay, we have revenue courts. So different for different purpose, we have different courts here. So suppose a criminal, for example, a murder case, we'll take a murder case. It is in a criminal case and it is in the district level. Okay, in the district court it is been heard. In that case, what happens is that the people or the victim side may feel that they have not got the justice. In that case, they can appeal to the higher court. And now above the district, which is the higher court? Above the district, the higher court is the high court. Okay, high court of the state. So that case they can appeal in the high court for the judgment or for the justice, isn't it? Now the very same then high court, and for appealing there are so many legal processes are there. So when it comes in the hands of the high court, then again the hearing, the trial sessions, everything will be gone based on the previous analysis. First it will be made sure that why this case has come from a district court to a high court. Okay, after studying in detail regarding the matters, the high court, once again the high court judges, much more senior judges, experienced judges, go through the case and they will be analyzing, and then if the district court has given a wrong judgment, then it will be corrected or amended, okay, in the high court. Now in that case, the district court judge is not having the right to question the high court judge that on what basis this decision is changed or taken or made or whatever punishments given. Sometimes it happens in the district court, the punishments may be like for 14 years, 15 years, and in high court after re-hearing the cases and restudying the cases, the punishment or the number of years might be reduced. Okay, but it's not necessary every time it happens like this. Now in this case, if the high court also sees nothing is wrong with the judgment of the district court and it has given the right judgment, and still the client or the victim feels that they have not yet received justice is denied to them, in that case, they can appeal to the Supreme Court of India. Okay, I hope you are getting me. Okay, so this is what you call it as a appellate jurisdiction. That is, now above the Supreme Court, there is no other court. Supreme Court is a superior court. Okay, so Supreme Court is a court of appeal which can reduce, and Supreme Court has the whole power. Neither the district court nor the high court can question Supreme Court that why it has reduced the punishment, why it has changed the judgment passed by the lower courts in the country. And this is the facility that the jurisdiction allows as a appellate jurisdiction. Okay, now in this, what type of cases are included in the appellate jurisdiction? Number one, constitutional cases related to the constitution matter. When high court is unable to handle or wants Supreme Court to handle an important case, then it sends such cases to the Supreme Court with a certificate. With a certificate means it should be in return. Okay, and then only the Supreme Court will be accepting that from the high court. Okay, then it sends such cases to the Supreme Court with a certificate, and in absence of the certificate, if required, Supreme Court can intervene and handle such special cases on appeal. So sometimes it again depends upon the importance and significance of the case. Okay, that how strong the case is, how strong the matter is, and in such cases the Supreme Court may ask for the certificate, or sometimes it won't even wait for the certificate. If the matter is of serious issue, it directly intervenes to handle the case on the basis of only a appeal. Okay, now another case is that civil cases. Now important civil cases with the High Court certificate or without the High Court certificate are also taken into consideration on the appeal. Okay, so appeal means it's like an application or a request made to showing all the necessary details and getting the signature from the judge of that particular court. If it's a lower court, if it's a district court, if it's a civil court, or if it's a sessions court. Okay, all this. Now below that comes the criminal case. Okay, important cases with the High Court certificate or without the High Court certificate also can be taken into appeal to the Supreme Court. Okay, so that means you have to keep in mind that appellate jurisdiction means it has the power to grant leave or to appeal, okay, against the judgment delivered by the any of the lower courts in the country to its higher court. Okay, now not necessary that directly from the district court or lower civil court directly it should be gone to the Supreme Court. Sometimes in High Court also it can be solved. Okay, so one level, which is a court that comes one level next to from the lower court, is that you can appeal there. Okay, Supreme Court is the last and the highest way of appealing it. Okay, the last and highest way where you can appeal, and after that there is no appeal. After that we have only one court, that is God's court. Okay, so, and that is not there in our Indian jurisdiction. So here we come to the criminal cases. So when we talk about the criminal cases, we will be discussing like what type of criminal cases, or two types of appeals can be done in the criminal cases that can be in the Supreme Court. Cases without the certificate of High Court, cases with the certificate. Now this is classified into two. One is cases without the certificate of High Court can be appealed to the Supreme Court. Then cases with the certificate of the High Court can also be appealed to the Supreme Court. So you might be thinking, then what is the purpose of certificate? Then if it is accepted without the certificate, then what is the purpose? Okay, now let us see cases where why certification is not required. Where the High Court has reversed the judgment of acquittal given by the lower courts and punished the accused with death sentence. In that case, there is no need of any certificate from the High Court, because High Court has already accused with the death sentence. Death sentence means the person will be imprisoned till his death. A case which is withdrawn by the High Court from a subordinate court and sentence the accused to death. Now, sometimes happens like this, that from a subordinate court or a sessions court, the case goes to the High Court, right? And the High Court feels that there is no wrong in the judgment given by the subordinate court, and High Court withdraws from taking that case. Okay, in the grounds that there is no wrong in the judgment given. So what judgment given in that is sentence court and sentence the accused to death. And if the accused is sentenced to death, then there is no need of any certificate of the High Court. Then that can be directly appealed to the Supreme Court. Okay, so these are the things that you have to keep in mind. Next we will move to certain writs. You remember we have discussed the writs. Now what do you mean by writs here? That is, we have discussed that protection of the fundamental rights, okay, where the court can issue several writs for the enforcement of these rights. Now different types of writs are here. One is habeas corpus. Habeas corpus, it means, the literal meaning of the word habeas corpus means to have the body. Okay, to have the body. By issuing such a writ, writ or the law, the High Court or the Supreme Court can get the body of any person, the custody of the body of any person released if it has been unlawfully detained by any person or any group of persons or by the state. Okay, this writ is thus a great safeguard for the personal freedom of the citizens. Now I'll just give you an example, like in our wars, during the time of the wars, the Indo-China War or Indo-Pak War, we see that sometimes it happens that many of the soldiers die and their dead bodies will be in the other country, right? Now, in the other country, no one will be there to give them the rituals of their religion and their country. So, in that case, the family members of, for example, we'll take India and Pakistan. For family members of the India can can appeal for a habeas corpus in the Supreme Court to get the body of that, and the Supreme Court will be taking necessary steps to and connecting with the Pakistan court, and then asking them to get the body through the habeas corpus. Okay, so this is one example. So it not necessary it happens only with the international matters. Sometimes it can happen with the interstate also. Okay, so next is that mandamus. What do you mean by mandamus? Mandamus means we order to perform a duty. That's the literal meaning of the word. So mandamus in Latin, it means we order. In Latin means to give an order. It is a command or an order from a superior court to the lower court. Okay, so these are all legal terms. When we have a lot of vocabularies based on the field we work. For example, if you are in a cooking field, you have a lot of vocabularies like cuisine, cutlery, like that. A lot of words you use in that particular field. If you're in a computer field, you can use the words like output, input, login, shutdown in that sense. Okay, so these are the certain legal words or legal terms that actually used only in the by the legal people who are involved in by the advocates, judges, or who are in law practitioners, etc. So mandamus is a word that means to put an order. Now what is that? It is an order or a command from any of the superior court to the lower court regarding what? Or an administration authority regarding what? Regarding to perform their duty. Okay, for example, like we also call it as sending a summon, summon. Okay, summon. Suppose in any government officer is not doing his government job properly, is not reaching the office on time, lots of files are pending on his work, on his table, and his works are pending, and then a lot of people are having complaints. He is behaving very rudely with the people. He don't have so he is using the government's money, and he is using the government's time and people's time. So a lot of complaints, if any complaint goes, and the person is involved with the bribery and corruption, so in that case, if anyone goes and files a case against him, the court gives a mandamus, okay, to that organization. It can be a factory, it can be an organization, it can be an institution, or it can be an individual person also. Okay, so I hope that you understood what you mean by mandamus. In simple words, you have to keep in mind it's an order given from any of the superior court to a lower court in regarding the matter of performing their duties properly. Okay, next we come to the writ of prohibition. What do you mean by writ of prohibition? The writ of prohibition is an order again issued by a superior court to the lower court. Now what is the difference? What the difference is that to stop proceedings in the case which might be in excess of jurisdiction of the lower court. Okay, so sometimes what happens, some cases will be from lower court, it is sent to the higher court. Okay, for example, like from civil court it is, or revenue court, it is sent to the district court. In that case, what happens? Suppose it is like, for example, I'll give you like demolishing a particular building. The lower court has given the order to demolish a particular building because it is the building has overtaken the government's property, or it has constructed in the government's property. In that case, the lower court government orders to demolish that building, and the writ, as per the writ of prohibition, if the person has appealed in a higher court, that is from lower court, civil revenue court to a district court, if it has appealed there, in that case, or to the high court, in that case they can give an order. Okay, that is what you call it as a writ of prohibition. Okay, next is the writ of certiorari. Learn the spelling clearly. Writ of certiorari. Okay. Now what is this? This is also an information, that is to be informed of what is going on. Okay. That is, this writ is issued again by the superior court to the lower court to a judicial authority desiring to be informed of what is going on. Means it, as per the writ of certiorari, it must be informed. Time to time information should be given regarding, suppose a criminal is being allowed to come out for the bail, isn't it? You know what is bail? A particular number of days they are allowed to stay, meet their family members, but they are always under the observation. They have to every day go to their respective police station of their area, and they have to go and sign. They are not allowed to go anywhere out of their leaving their city, or neither leave the country or the state. So so many rules are there. Okay, so at that time it is should be informed, the related to that person, what is going on with that person, what is he involved in or not, etc, etc. Okay, so this is what you call it as a writ of certiorari. Then next we come to quo warranto. What do you mean by quo warranto? It means by what order, in what sense, in what order. Okay, by what means. You know, simply in the class, if a teacher makes the student to stand up, and the student's first question will be what I have done, isn't it? Okay, though he has done or he has not done is not a question there, but the first question comes in his mouth or in her mouth is that what I have done. Okay, yeah, so that is, it's a like type of a quo warranto. So by what order? So if the teacher punishes, then sudden question arises, what I have done, why are you punishing me, or why should I get this punishment? So by what order? But in jurisdiction, quo warranto is not that, it is different. In jurisdiction, quo warranto means by what order, that is, it is issued when a person has usurped any office. Now what do you mean by usurping or usurpation? Usurping means taking the power of someone by force, by cheat, or by treason. Okay, that you call it as a usurping. You know, we have many of the people filing the cases regarding the land issues. Okay, in the revenue courts, that his neighbor has usurped their land, or constructed in their land, or such issues. We see a lot of cases are being filed on that. So, or maybe also even in the institutions, or in the factories or organizations, usurping the power always occurs. Okay, so people do that by treason or cheating, or making use of the advantages of the person being good to the other in any ways. Okay, so it is issued when a person has usurped any office. This writ thus prevents the public officers from forcefully or wrongly holding a high public office. Okay, so this is what you call it as a quo warranto. These are the some important writs that you have to keep in mind. Okay, and learn the meanings and definitions properly. Next we come to the third type of jurisdiction. So we have already seen original jurisdiction, appellate jurisdiction, and now we are going to see advisory jurisdiction. Now what do you mean by advisory jurisdiction? Again, from the term it is very clear. Advisory means to give advice. Okay, so President may refer and send a case of special importance or regarding any law for consideration to the Supreme Court, and this power of Supreme Court to handle such cases is called as an advisory jurisdiction. Okay, now cases regarding what type of cases are taken into consideration in the advisory jurisdiction. Cases regarding the disputes of pre-constitution period are also handled under this power. Okay, for example, pre-constitution period, like before the constitution has been framed. So the this is what you call that advisory jurisdiction. The Supreme Court may require to express its opinion in two classes of matters in an advisory capacity. What is that? Number one is that any question of law may be referred to the Supreme Court. Any question of law can be referred to the Supreme Court if the President considers that the question is of public importance. Okay, so if the President thinks that that question is of public importance, then that question can be, President can ask the advisory, through the advisory jurisdiction in the Supreme Court, to consider that particular problem or the question or the issue. Okay. Now another thing is that such opinion of the Supreme Court is advisory and not binding on the government. So when the Supreme Court gives an advice, okay, now in the pandemic situation we had the lockdowns, isn't it? So the lockdown and controlling of the traffic, the new rules initiated to the police, rules initiated to the law, to the government. This is all advised by the Supreme Court because it is a matter of the public importance, matter of the public safety. Okay. So such opinion of the Supreme Court is advisory and not binding. It's not on any ruling government's rule, binding on any ruling government or executable or any legislative or nothing else. Okay. So disputes arising out of pre-constitution treaties and agreements which are excluded from original jurisdiction by Article 131 will be also the Supreme Court expresses through the advisory jurisdiction. That is, in the original jurisdiction by Article 131, if any disputes are being excluded or it is not taken into consideration, that can be advised through advisory jurisdiction in the Supreme Court. Okay. So I hope that you understood what do you mean by advisory jurisdiction. Now let us come to the next type of jurisdiction, that is revisory jurisdiction. Now advise and revise sound similar, isn't it? So Supreme Court is empowered to review any judgment or an order made by it with a view of removing any mistake or error that might have crept in the judgment or order. This power of Supreme Court is called as a revisory jurisdiction. Revise, its very word and term is related. You are asked to revise your lessons. What do you mean by that? Revise your lessons means you will be rereading it, you will be restudying it, you will be once again trying to find out the things and get the things done, clarification, right? So in many of the cases which are being transferred from subordinate courts to the higher courts, the Supreme, and it is being revised. As I told you, it's not like since the court has sent from lower court to Supreme Court, I have to give my own decision. No, it's not like that. Why that case is being if it is come through appellate jurisdiction, or if it is come through original jurisdiction, or if it is come for the revisory jurisdiction. So the first thing is that it will be revisory jurisdiction is done to find out why this case has come from lower court to the superior court or from high court to the Supreme Court, etc. Okay, and it will be finding out if any mistakes are done by the lower courts, okay, or high court or even subordinate courts, that will be corrected by the Supreme Court. If okay, the word if is very important. If anything is there, or any error that might have crept, or even the error that might have crept in the judgment, giving the judgment. Maybe sometimes the lower court judge has given 15 years of imprisonment. Maybe that particular case is not that serious that you give the 15 years of imprisonment. Okay, so in that case the judgment can be revised, okay, by the Supreme Court, and no lower court has the authority to question the revised judges made by the Supreme Court. Already we have seen this. Okay, so Supreme Court's judgment is considered as a final judgment. So this is what you call it as a revisory jurisdiction, and this is done because Supreme Court is a court of record, and we are going to see what you mean by court of record. Its decision has special importance and can't be questioned in any other courts. Okay, is that clear? Next we will come to the judicial review. Okay, judicial review means what? Again, what do you mean by review? Review of a book, review of a film. That means what? You are getting the all the details related to that matter. Okay, so that is what you call it as a judicial review. Now what do you mean by judicial review? Means the review is done in the matters of the cases or punishments or dealt with the court. A review, again it's like a rechecking, reanalyzing it. Okay, if it is so the Supreme Court is the interpreter of the constitution. So already I have said this. Supreme Court is the interpreter of the constitution and its decision is final, right? In that case, it has the power to review laws passed by the union or state legislatures. Review means what? पुराना जो रूल्स एंड रेगुलेशंस था उसको रिव्यू करके नया करके या उसमें कुछ चेंजेस करके उसको दोबारा लॉ बनाना is what judicial review does, in short, if I have to say. So the laws passed by the union or the state legislature, if the law is found against the spirit and provisions of the constitution, then Supreme Court can declare such law ultra vires or null and void. Now what do you mean by ultra vire, null and void? Ultra vires means actually it refers to null, nothing. Void means empty. So that means कोई भी ऐसा रूल जो पास किया और सुप्रीम कोर्ट को लगता है कि ये सही नहीं था जो यूनियन और स्टेट लेजिस्लेचर्स ने पास किया, तो सुप्रीम कोर्ट का पूरा हक बनता है कि वैसे रूल्स को रद्द करे या दरखास्त करे. ओके, नॉट टेकन इनटू कंसिडरेशन, दैट यू कॉल इट एज अ, डिक्लेयर इट एज अ अल्ट्रा वायर्स और नल and void. And this power of the Supreme Court is called the judicial review. Okay, that means what? Supreme Court, I have added a beautiful picture here. You can see Supreme Court is like I am your protector. Okay, who has the right to question me in that sense? So I am the protector of whom? Protector of the constitution, protector of the people, and no other court has, not even the government or any organization or any powerful person like president or prime minister have the right to question the Supreme Court's authorities. Okay, so next we come to the last topic, that is of the day, not of the chapter. So that is court of record. Now what do you mean by court of record? You know, in school, after suppose you come after 5 to 10 years, after later 5 and 10 years you come back to your school and you need the records of your marks of class 10. So you will be coming to the school, you will be approaching, trying to collect it. How you will get this? Okay, you will be getting this because the school will be maintaining a record of your marks entered, okay, and it will be maintained in the file or nowadays in the computers. Okay, so that anytime you approach your school and if you know the year which you have passed, and you can get the details of your marks. So many times it happens. So this is followed in almost all the institutions, educational institutions especially, and even in the offices also related to their matters, etc. Now what the court of record also does the same thing, isn't it? You know, for court of record, it is the court's rule that they have to preserve all the case files in the record room. Okay, that is Supreme Court is a court of record and all its judgments are recorded for evidence and testimony, for further evidence and further testimony. You know, बहुत सारे cases ऐसे होते हैं कि सालों बाद उसको reopen किया जाता है and on what basis and on what grounds कि ऐसा लगता है कि इंसाफ नहीं मिला उस इंसान को और कई सालों से वो इंसान जेल में है या पनिशमेंट, he is under the punishment for which he has not given. So you might be asking कि that जब कोर्ट ये सारा रिवीजन रिव्यू सब करता है तो ऐसे बेगुनाह को सज़ा क्यों मिलती है? कोर्ट doesn't go for the person, court goes on the evidences provide. अगर जो इंसान कितना भी बेगुनाह हो और evidences जो कोर्ट में दिखाया गया या फिर वो उस इंसान के खिलाफ है, the court will be giving the judgment based on the evidence. Okay, and in today's world you know very well that evidences can be very easily or very fakely it can be produced. इतना करप्शन भर गया कि किसी के भी पॉकेट भर दो, you will be easily getting a wrong certificate from a doctor, a wrong certificate from any person, so that an innocent can be proved as wrong. Okay, so that means सो ये जो केस अभी कोई डिसीजन सुना के बंद हो गया लोअर कोर्ट में और सालों बाद ये लोग ट्राई करते रहे कि इंसाफ मिले एंड इट कम्स टू द सुप्रीम कोर्ट, तो उस समय सुप्रीम कोर्ट जब ये केस रीओपन करता है या हाई कोर्ट रीओपन करता है तो ये case file is very important. The evidences submitted at that time is very important. Okay, so now this is what the court of record does. It keeps safely all those evidences, matters related to that, and the file of the case, everything, every minute details of related to that case, it will be kept as a record. Okay, so these judgments serve as a precedence for high court. Precedence means as a to check for high court and subordinate court, so that in case of doubts they can refer to the records of the Supreme Court and give a similar decision in similar cases. Not only this, sometimes it happens कि कुछ cases same similar लगते हैं, right? And in order to solve that case, you can go and study the case which had been found a solution years back. So many of the connecting links you will get, many of the loopholes you will be able to find out, and for all this purpose this court of record plays a very important role. The Supreme Court records aren't to be questioned, and the Supreme Court records जो कभी कभी करप्शन इतना बढ़ जाता है कि कभी कोई केस रीओपन होता है तो इवन द फाइल्स भी गायब हो जाते हैं या फिर गायब करवा दिया जाता है. ओके, एंड दिस हैपेंस ओनली इन आवर कंट्री, द ग्रेट इंडिया. सो द सुप्रीम कोर्ट रिकॉर्ड्स aren't to be questioned when they are produced before any subordinate court. It found Supreme Court can punish which such person for its contempt, and no one can deny this right of the Supreme Court. So this is what you call, or what we understand by the court of record. Okay, now there are certain implications of the court of record. What are those implications? Is that the court of record has mainly two implications. One is its judgments and orders are preserved as record. So whatever the judgment given, how many number of cases are heard, how many number of cases are finally declared and sorted out, all these things are preserved as a record in the Supreme Court, and these can be produced in any court. Now for the further clarification, if it is required, these records can be used by any of the lower courts or subordinate courts. And if a person commits a contempt of court, now what do you mean by contempt of court? They will be breaking the laws of the court. Okay, if it is a judge or even if it is an advocate, okay, they break the contempt of the court. The bar council, the court, the advocates are having a council, and that council is called as bar, BAR, not that bar that we see in our local streets. Okay, so this is a term used only for the council of the advocates, that is BAR, bar. Okay, so the bar council will be finding out this contempt of the court, and the court has, and informing the higher authorities, and the court has authority to punish him. No authority can deprive the court of this right. Sorry, it is misprinted as night. It is right, RIGHT. So Supreme Court acts as a guardian of the Constitution. In short, we can say that Supreme Court acts as a guardian of the Constitution. So here just is a picture of the court of record. You can see that court of record means previous years files, cases, even in, as I told you, example in schools and all, in colleges, in universities, they all keep this court of record related to the question papers, related to the office files, related to the information regarding the students who have passed out and cleared the examinations, and who are pending, and who will be going for the latent exams, etc. Okay, so this is what we call. So I hope that you understood this much part. We will be continuing in the coming video the rest of the chapter, that is the functions of the Supreme Court, tomorrow. Thank you for being with me. Have a wonderful time.